Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Responding to a Potential Privacy or Security Breach, Internal and External Strategies. Just a quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. And today's presenters are Michael Cook and Regina Morano.
All right, it's up to us. All right. Hey, listen, thanks everyone for joining us today. Regina and I are going to be discussing the responding to a potential privacy or security breach at your agency. Just to introduce ourselves, my name is Michael Cook, and I'm a partner and co-chair of Lyles Parker's Healthcare Practice Group. I've practiced healthcare law full-time for almost 50 years, first representing the federal regulators of the Medicare and Medicaid programs as an attorney at the United States Department of Health and Human Services, and then for the last 42 years, representing virtually every type of healthcare entity in private practice. I've also served on health policy and transition teams for several governors, and more recently served as a volunteer on health policy teams for the presidential runs of Pete Buttigieg and President Biden's campaigns. I also just completed my term as chair of the board that oversees Virginia's Medicaid program as an appointee of 2 governors, and I'm a fellow of the American Health Law Association. Regina, you want to introduce yourself?
Sure. Good afternoon, everyone. This is Regina Morano. I'm a regulatory and compliance counsel, also with Lyles Parker. And I've been practicing law for 27 years, exclusively health law. Began my health law career as a Jesuit volunteer, working with homeless women in the Healthcare for the Homeless program in Baltimore. I have held key legal and compliance positions with hospitals, physician practices, managed care and regulatory organizations, as well as long-term care and home care and laboratory. I was previously Chief Legal and Compliance Officer with the University of Maryland with the faculty physicians, and also previously Vice President of Legal and Regulatory Affairs with Thompson Health University of Rochester System. Also served as lead regulatory and compliance counsel for the largest not-for-profit Blue Cross Blue Shield plan in New York. And was appointed by then Governor George Pataki in New York as a special counsel to the chairman and ethics officer for the New York State Workers' Compensation Board. And in that role, I had the opportunity to author regulations establishing certain legal protections for injured workers. I've done frequent speaking on healthcare compliance and legal ethics for both the American Health Lawyers Association and the National Healthcare Compliance Association, of which I have been a member for 20 years. And that, I think, that covers me, Michael, and I think we can probably get started with the presentation.
Fantastic. And as you can tell, we've both got very extensive bios, and hopefully we'll be able to impart some good information to you today. As part of our discussion, we're going to be providing you some necessary background on the privacy and security breach rules. And at the outset, I'd like to mention that we'll be focusing primarily on federal legislation in the area. However, while the federal legislation generally controls and preempts state legislation, where the state legislation is more restrictive, it takes precedence over the federal HIPAA rules. And Texas, as you guys I'm sure know, has its own privacy law. So as an example, Texas has a privacy law that's more restrictive than the federal law in what it considers to be a covered entity. For the feds, as we'll discuss shortly, it covers any entity that transmits, Gino, go to slide 3 if you will. It covers any entity that transmits information in electronic form for standard transactions such as billing. In Texas, a covered entity is not limited to electronic transactions. So, for example, it would cover entities that transmit paper bills through the mail. Also, a Texas Attorney General opinion requires data breaches to be reported to the Attorney General's office as well as to the federal sources again, that we're going to be discussing later. So while we will be discussing the federal provisions on security and privacy, you need to keep in mind that there are state requirements as well, with which you've got to be familiar. And as the slide states, the best way to think of this is that HIPAA serves as a floor, not a ceiling. Gino, you want to go to the next slide? HIPAA privacy and security have been around since the 1990s. They were basically part of the Health Insurance and Portability and Accountability Act of 1996. And when that act was first enacted, it had numerous provisions and it covers a wide variety of areas. But the principal area of discussion was the insurance protections for individuals. However, also tucked away, there was a short provision, basically a sentence, that addressed privacy and security protections for healthcare information. And at the time, most of us who were practicing law gave it very little focus. However, all that changed in December 2000 when HHS published the first privacy rules under HIPAA. For those of you who are old enough to have been working in healthcare at the time, the rules were absolutely voluminous. And on top of that, they were so complex that the Office of Civil Rights, which is, as you know, the agency at the feds that enforces the HIPAA and the privacy and security rules, issued numerous federal FAQs on their interpretation. So you might have one page of the regulation and one section of the regulation and a whole bunch of FAQs that were being consistently added to. And in the legal field, those of us who were in large firms remember the development of multi-departmental HIPAA task forces to understand the various tentacles of the rules. We were on the conference speaking circuit with security experts and privacy advocates, and it took on a life of its own. I even remember working with the healthcare department of a major national law firm that I was at the time, developing a complex provision-by-provision preemption analysis that compared Texas and federal law for a major trade association of Texas providers, and similar compendiums were being developed throughout the country. This slide simply sets out the various timelines and statutory and regulatory changes, with the last major changes in the regulations having occurred in 2013. And they've now become a standard way of doing business in the industry. Gio, do you want to go to the next slide if we can? Okay, now to the meat. First, who is a covered entity under HIPAA? A covered entity under HIPAA is generally a health plan, a healthcare clearinghouse, or a healthcare provider that transmits any health information in electronic form in connection with a standard transaction. Merely using email isn't sufficient to make you a covered entity, but rather it's got to be in connection with a standard transaction such as billing or the transmission of medical records. There are also entities known as hybrid entities, which are entities that have business activities that include both covered and non-covered functions. As an example, a large paper box company may also provide health insurance through a self-insured plan for its employees, and that latter function would be covered by HIPAA. Obviously, the paper box company as a whole generally would not for its other activities. And finally, where a covered entity engages a business associate to carry out its healthcare activities and functions, the security and privacy rules of HIPAA also apply to these entities. I'm sure that each home health agency or hospice on this call has developed a business associate or even subcontractor business associate agreement that it requires its vendors who handle protected health information to sign. But the key point to remember for these agreements is that the Health Information Technology for Economic and Clinical Health Act of 2009 that we refer to as HITECH, which is principally remembered for providing grants to certain types of entities to enable them to make expenditures for interoperability, also made business associates liable for compliance with certain parts of the requirements of HIPAA. And this in turn has raised a number of issues when you're dealing with business associates, such as trying to negotiate indemnification clauses for breaches for which a covered entity is principally liable, but that are also caused by a business associate. And just as an example, about 5 or 6 years ago, we were developing a security and privacy plan for a client, and they had an issue with a host of a website. Now, the website was getting very limited payment from the healthcare entity, and as you can imagine, they balked very heavily at the indemnity issue, and there was far more negotiation because it was early in the process of that provision than you should ever be asked to get involved in, but it can create some really thorny issues. Gio, next slide, if you would. This slide simply discusses some of the considerations for home health and hospice providers that are small and mid-sized. As the slide states, the law allows for scalability, which can keep some compliance expenses down for these entities. However, there are some real challenges in these organizations, such as dedicating the necessary space to keep unauthorized persons from areas where PHI is accessible. And keep in mind that as the slide states, these providers still have to comply with the privacy rules. Also, unencrypted laptops really represent the most common risk for handling protected health information. As home health agencies and hospices, you've all had the story of the laptop stolen from nurses or workers' cars hammered into you, along with the need to ensure that the laptops are encrypted. And our firm privacy officer has even counseled us to require laptops stored in our homes to be locked to our desks or home offices when we're not attending to them. As you can imagine, she's not the most popular person in the office when she makes these suggestions, but they're good ones. And there's just an example of a case where a large healthcare provider retained an outside contractor to conduct quality improvement audits of their medical care. The quality assurance auditor shared the information with a subcontractor, records of almost 10,000 patients, which was stored on an unencrypted laptop, and that laptop was stolen as part of a home robbery and had not been recovered as of early 2022. And as an aside, if the provider is assessed a fine by OCR, the contractor and subcontractor likely are going to be sued, especially if there's an indemnity clause in the BAA, that the business associate agreement they signed. And also, as Regina will talk to you about later, the contractor can receive fines through OCR. But the most important thing to remember is that the provider, as a covered entity, is ultimately responsible for any breach. And again, Regina is going to go into that further with you shortly. One thing that is also worth mentioning, and again, Regina will cover it in greater detail, is the fact that that it's an insurable risk, cybersecurity insurance, and something that you'll want to be considering. Also, the rule does not cover de-identified information where all 18 identifiers that are listed by home health agencies have been removed. However, the 18th is a real catch-all that states any other unique identifying number, characteristics, or code, such as an HIC number or characteristic. And there's an example where a doc who worked for an emergency room in a hospital was cited for HIPAA violation, even though he posted information on social media regarding a recent trauma patient that didn't cite any of the specific 17 traditional pieces of identifiable information. The facts of the case were unique enough for members of the community to readily identify the patient, and as such, this was considered a breach. And the employee hospital fired the doc, who was also reprimanded by the state medical board, not something that anybody wants to go through. So while scalability does not remove the requirements for complying with the privacy rule, an example where scalability would apply to a small provider is potentially allow for the appointment of a privacy officer who has other office or clinical duties. And the security rule also provides that covered entities may use any security measure that allows the covered entity to reasonably and appropriately implement its requirements. Just to focus on the four measures, security measures. In deciding which security measures to use, a covered entity must take into account the size and complexity of your organization, technical infrastructure, the cost of measures, and the probability of risk. Gio, can we go to the next slide if we could? It's also critical to recognize that organizations remember the critical premise when requesting, reviewing, handling, or disclosing PHI, which is quoted on this slide. Namely, organizations may only release PHI as explicitly permitted by the rule or with prior written consent of the individual who is the subject of the records. Moreover, when access is permitted or required, the minimum necessary standard applies. And the minimum necessary standard requires that when a covered entity accesses or discloses protected health information or requests health information from another entity, the entity's got to make reasonable efforts to limit protected health information use or disclosure to that which may reasonably be necessary to accomplish its intended purpose. And the example, the apocryphal example that we always talk about is, does the billing clerk really need to access a patient's entire medical record, or does the janitor really need access to the record? And the question answers itself. Slide 8, please, if we could. Next slide. Gio, this slide lists the basic rights of patients under HIPAA. The right to receive a privacy notice, to know when and to whom there has been a disclosure, to request restrictions on how the provider communicates information, especially to health plans, when the patient is paid for the services out of pocket, to make copies of privacy notices, to access records except in limited instances, and you can charge a reasonable amount for copying records, but query, give a little thought as to whether you really want to do that. To amend, the patient has the right to amend his or her file. They can't order the physician's records, but they can add their own comments. They can have the right to complain of violations. And you must explicitly plan for tracking disclosures on a regular basis. You've got to keep a log of all disclosures of patient information, and also must plan for patient communication. For example, does the patient prefer phone calls, whether it's permissible to leave a voicemail or an email, and to adhere to the patient's preference. And I'm sure each one of you has that when a patient checks in, and certainly when you go to your local physician, your physician's office is always asking you, how do you want communication? Can we go to the next slide, if you will? As this slide notes, there's a tiered penalty structure for violations of HIPAA or for breaches. Under HITECH, as it mentions, there are now mandatory penalties for willful neglect. As of 2009, CMS is required to base its penalty determinations on the nature and extent of the violation, whether the violation has been corrected. And they've got to consider whether the violator knew he or she was committing a violation and the level of correction within the organization. The range of CMPs depends on whether the individual is a first-time or repeat violator. And as you can imagine, a violator's efforts to follow the rules, as evidenced, for example, by a compliance plan and security and privacy plans, may also prove persuasive when you're seeking to have the agency waive or reduce any proposed penalties, or to possibly settle the matter entirely if the provider takes additional remedial steps. Like the covered entities, business associates may now be liable for the CMPs, and obvious ones. They can't threaten, business associates cannot threaten or retaliate against anyone who files a complaint against them. The next slide, if you would, Gio. This slide just shows you the tiers of the penalties of the CMPs. Regina is going to go into it in far more detail, but as you can see, the lowest penalty applies if the offender didn't know and by exercising reasonable diligence would not have known that he or she violated the law. You go up a step if the violation was due to reasonable cause and not willful neglect. A further step if the violation was due to willful neglect but was corrected. And the last that you never want to be in is it applies if the violation was due to willful neglect and was not corrected. Regina, you want to pick up from here?
Thank you, Michael. And, Michael has brought up some really interesting points in his section of the presentation so far. I'd like to amplify a couple of those points. When talking about the HIPAA security portion under the HITAHCH regulation, there are requirements for how and when electronic protected health information has to be safeguarded. And it's important, as you're putting your plan together or updating your plan annually, it's important to remember that the technical safeguards under the security rule, some are mandatory and some are addressable. And that's where that issue of scalability in part comes into play as well. You have to take into consideration how large is your organization, what's your patient population, what's your ability to pay for more complex security, technical safeguards, et cetera. You take those sorts of things into consideration when you think about whether or not you are going to go forward with a so-called addressable security standard. And of course, if the standard is stated by under the regulation is mandatory, then of course it's mandatory. You must comply with it. You must put that security step in place or that standard. Another thing too, I think is really helpful, having been in healthcare a certain number of years, we often hear people say in healthcare or people who have no healthcare background, we often hear folks say, well, that's a HIPAA violation, when in fact it's not. And we've outlined for you so far in the presentation what is a covered entity, when does HIPAA apply, and even sometimes in an employment context or other context, where the disclosing individual is not a healthcare provider or is not a covered entity. Sometimes there's confusion out there around whether or not HIPAA actually applies. You might come across that in your work environment. You might come across that elsewhere, and it's important to kind of stick to that analysis that Michael laid out for us in the beginning. HIPAA really only applies if you're a covered entity or a hybrid entity, like a billing company, for example, or if you're a business associate. So just another sort of key piece to keep in mind. And then again, when we're talking about unique identifiers, when we're talking about what does constitute protected health information, sometimes folks are surprised to know that, obviously we know our name, our address, our claim ID number, our doctor information, that's all protected health information, but it does go farther than that, our telephone number, that sort of a thing, but it does go farther than that. And really anything that is a zip code or smaller is considered protected health information. So I just remember a case a number of years back, there was a community group that used to make donations to families in their community who had cancer patients in their family. And they would have they had meetings and they would have luncheons, and they were, at the time, they were reporting out to the membership, well, we donated, X $100 to a family in zip code, 22222, whatever the zip code was. And that actually is not permissible under HIPAA to talk about a healthcare patient who, just limiting the description of them even to a zip code. So we have to always just be on guard. And that's what leads to discussion, the more detailed discussion around the penalties. And, Michael went through the tiers for you. I'm going to talk about, starting on slide number 11, I'm going to talk about the penalty structure. So if you've been following HIPAA for a while, you may remember, the HIPAA penalties started out with nice round numbers, right? So for example, in that first box on tier 1, the minimum penalty started out around $100. And what happens is every year, HHS, who is the fixer of the penalties, they adjust those numbers every year according to an index. And they adjust the penalties for all of the laws and regulations, the civil monetary penalties that HHS, Health and Human Services, is responsible for establishing and monitoring. So the last update there was an update due a couple of months ago and it hasn't come out yet, but the last update from 2022, which is carried over, these are the numbers. So if thinking back to what Michael mentioned a moment ago, if you're at the tier 1, sort of that, lowest level of culpability where you or your organization did not have knowledge of the violation and reasonably wouldn't have had knowledge, that you can demonstrate, well, we have some safeguards in place. We have set up our system to guard against this type of unauthorized access or disclosure, and you can demonstrate that you didn't have knowledge and you took some steps to ensure that you would have knowledge if something went awry, then the minimum penalty there is $127. The maximum penalty there, though, is $31,987. And you have to think about, how could you, if you didn't have knowledge and you reasonably could not have been expected to have knowledge, how could a penalty go that high, up to almost $32,000? And really the answer is, I think, the scope of how many individuals are affected. So, you may be an innocent, relatively innocent healthcare provider or covered entity, but it's a heavy responsibility that we all have, right, to protect the health information and the records of the patients. And where that goes awry, someone is accountable, and that someone is the person or the place where the disclosure occurred, because you can't have high volume of folks affected without some significant or material compensation. So the second level there, reasonable cause, right? So, there might be a reasonable explanation as to why something occurred, but nonetheless, you had knowledge of it, or perhaps you didn't take sufficient steps to create safeguards around the PHI. So the number goes up there. Starts at a minimum of 1,280, it goes up to 127,974, and all of a sudden we're talking about real money, right? And then this willful neglect, really, this is sort of the category of, you really didn't care, you really didn't take care of the information, and the penalty is going to sting. So for one, for the minimum penalty there, maybe in a case where only one or a small number were affected, that penalty is $12,794, and it goes up to there's an annual penalty. It goes up to $63,973, but there's an annual penalty cap there of $319,865, which means that for the same, and that's what all these annual penalty caps are about, for the same violation, HHS can assess $31,000 or $63,000 per violation that's related to a specific incident or disclosure. But then there is a permanent cap on that. There's an annual cap on that. And then, of course, that category of tier 4 that Michael's talking about, the numbers are pretty high there. For a minimum 63,000, and the maximum also is 63, and then there's an annual cap there of $1.9 million. So you can see over the course of the life of HIPAA, these numbers have become very, very real. So if we could, Gio, could we go to the next slide, slide 12? I just wanted to give a few examples. There are literally hundreds of settlement agreements out there. There's an index list out there on the HHS OCR website, but these are just some of the more recent ones. There was a MedEvolve case that involved 230,000 patients, and the penalty there was 350,000. So my sense there is that there were quite a number of patients involved, but because, it's only, if you look at it, only a few dollars per patient, my sense is that the culpability, that HHS decided there was not significant culpability there for MedEvolve. But there was a private practice, an individual practitioner. I didn't put the name here, but the name is on the OCR website. There was a private practice case within the last year, affected one individual, and that penalty amount was $15,000. So they were in the realm of, looks like a tier 3 violation. And then Banner Health, which is a really highly regarded healthcare system that started out west. I think it started out as one of the Catholic health systems out in the California western part of the United States. They had a disclosure of almost 3 million patients and ended up paying a fine of 1.25 million. And then there was the lab violation, Life Hope Labs. Again, only one person affected, but the penalty was $16,000. So, HHS is really on this, and I'm going to give you some numbers in a moment where I can tell you about how many cases they've actually handled.
Yeah, Regina, can I just jump in for 1 second? Regina's given you some fantastic information, and for those of us, just to understand the evolution, for those of us who were around at the beginning here, for a while, for a fair amount of time, OCR did not impose any significant penalties except in really egregious cases. But as you can see from what Regina's telling you, the world has changed dramatically over the last number of years. Sorry, I didn't mean to interrupt.
No, that's a really great point, because that's true. It was only recent last few years. HHS telling us, you need to get ready, you need to get ready, you need to will start enforcing, and it's really only in the last few years that we've seen enforcement that looks anything like this. And actually, as of March of this year, OCR handled 325,000 complaints, and they have resolved and closed 97% of those cases. There were 325,000 complaints. We have 8 currently open, so they are fully staffed, and they are in a they're in a phase of significant enforcement. I think that's a really good point. It is so. We can go to the next slide. I did talk about the factors that was considered. So it's the secretary members, the secretary of Health and Human Services, who's really the head of all HIPAA enforcement. But all of that responsibility is delegated by the secretary to OCR, which is Office of Civil Rights, and that is one of the primary responsibilities of the Office of Civil Rights. So when they're looking at whether and how much of a civil monetary penalty to assess against a covered entity. They look at certain factors that we've kind of hinted at. So, one of them is the nature and the extent of the violation. As I was mentioning in the case examples on the last slide, they'll look at how many people were actually affected and how long did this go on before somebody caught it. It's very, very helpful when you have safeguards in place, on your EMR, for example. If you do routine auditing and you're checking a certain number of folks every month and you're looking at what are they looking at, and you catch fairly early that you have a snooping employee out there, and you can demonstrate that to OCR, that is going to help you significantly. And catching it early before there's too much damage, it does show good faith, and it certainly does assist when you're being evaluated for penalties. And then the nature and the extent of the harm. Michael mentioned these lost laptops are such a huge focus in terms of constituting a significant number of the violations. But another really huge focus, unfortunately, are folks who work, for example, in billing companies, or even just at the front desk or at some point in the healthcare continuum where they have access to patient information, including social security numbers, including, addresses, dates of birth, things that can help break into or access credit information or financial institution information. And this is a real risk. And this is something that OCR tries very hard to guard against and wants us as healthcare covered entities to guard against. So they will look at, was there physical harm? Did a stalker find someone and harm someone due to an unauthorized access? Was there financial harm? Was someone's financial identity stolen? Was there reputational harm? I had a case, very sad case, involving a hospital a few years back where someone called the hospital impersonating a family member and confirmed that someone was pregnant who didn't want that information to be known. And there was, there was harm there. There was reputational harm to the person who was trying to guard that information for herself. And that was viewed as a very significant incident at that particular hospital. And then the history of prior compliance and whether there were prior violations. If you look at the cases, as Michael and I have done in preparation for today, where we're seeing the larger violations are places where we are seeing repeat violations, right? So, I'm sorry, where we're seeing the larger penalties are, in many cases, places where they have had prior violations that are uncorrected. That's that top tier of liability that we all want to avoid. And then, believe it or not, HHS, OCR will take into account what's the financial condition of the violator. They will look at, perhaps they may determine that a significant fine would be appropriate, but at the same time, they will look at, will this significant fine or penalty essentially put a healthcare provider out of business or jeopardize their ability to provide care? Will they have to shut an emergency department? Will they have to shut perhaps a birthing center or a cancer treatment clinic? They will absolutely consider those things. And I've had cases where they have done just that. And then there's this open-ended piece of it. Are there any other considerations that they need to think about as a matter of justice, either with regard to the violating entity or person, or with regard to those who may have been victims of a wrongful disclosure? Those are the sort of human, those last two elements are sort of the human aspects that HHS will look at. So let's go to slide 14. And then these are risk areas. These are sort of the areas where we do see violations occurring. So impermissible use and disclosure of protected health liability. And this is where these are cases where hospital employees, for example, are using PHI for personal gain. or physician practices are giving access to medical records to marketing providers. Maybe a durable medical equipment provider is buying a list, or used to buy lists from physicians. Or, I'm not sure if you remember, there were a couple of sort of famous cases coming out of California. There was a case where George Clooney, a very well-known movie star, I think he broke his ankle in a small car accident, and there were multiple folks at this particular hospital in California. I think it was Cedars-Sinai, where they, or maybe it was, actually, I think it was UCLA Medical Center. There were two cases there, one involving George Clooney, where folks accessed his medical records and tried to sell information to, tabloid publishers. And then there were a couple of cases involving Britney Spears, who I think we all know was hospitalized a couple of times. There were cases where folks hacked into her, or, accessed her medical records and tried to sell that information to tabloids. And I'm sure we're all well versed in the fact that it's very possible and highly advisable if you have famous patients, and they don't have to be movie stars. They could even just be, sort of well-known folks in your own communities, that there is a way to lock down access to individual medical records. And it's highly advisable to do that where you think that there may be a likelihood of snooping. And then the next bullet there, lack of safeguards around protected health information. There really is an expectation and a requirement that providers are going to do that annual checkup on HIPAA and high tech on the security, do the security risk analysis and create a work plan from it and make corrections. And if you haven't done that this year, or you haven't done it ever, we strongly recommend that you get that done, whether you conduct it yourself, which is possible to do, or whether you reach out to a security contractor to help you do that. And then there are lots of cases of patients being denied access to their medical records. Patients have an absolute right of access to their records, for copies of their records, and also under HIPAA, but also under state law. And sometimes state law in New York, for example, where I practiced for a number of years, the penalties are even tougher than HIPAA. So be aware of your state regulations around that as well. And then disclosing more than is minimally necessary. So, if you're in home care and your nurse or your PA or your NP are sent to a location to treat, maybe you're sending a physical therapist out to treat, maybe a shoulder injury or an ankle injury. You really need to give serious thought to whether or not you need the whole history of pregnancy or pregnancy loss or cardiac treatment, or, any sort of whole person health records there. You might just need maybe the surgical record and or the injury record to get that, to do adequate work, from a physical therapy or an occupational therapy perspective. And disclosing more than is necessary is clearly has been viewed as a violation, a violation of that minimum necessary standard. So I'm just watching time here. I'm going to get you through the last slides with plenty of time. So what is a breach? We can go on to slide 15. What is a breach? It's essentially, it means that someone acquired or accessed or used or disclosed protected health information in a way that's not permitted. And I think we're all familiar with what is permitted. There is a whole list of circumstances under which we're permitted, healthcare entities are permitted and healthcare workers are permitted to access PHI for payment, for treatment, for healthcare operations. Those are the primary areas in which the disclosure of healthcare information is permissible. if you're outside that sort of realm, you have to really consider whether a breach has occurred. And certainly unauthorized access, people snooping in records, or a laptop being stolen, those types of things clearly are a breach. What's not a breach are unintentional and inadvertent. So, maybe you have a person handling your billing, or even someone registering a new patient. And many times you'll find patients have the same or similar names, but they're two different people. So if Regina Morano is going in, is getting home care for follow-up on a broken leg, and Rita Morano also is being treated by your home care agency, but someone accidentally goes into Rita's record instead of Regina's, that's unintentional, and that's not considered a breach. And, also inadvertent disclosures. We hear about inadvertent disclosures all the time. Maybe that means sort of overhearing something about a patient that you're not involved in, those sorts of things. And if you need help on those, hopefully your compliance or privacy officer is sort of schooled in that and can help you with that. But we certainly can help you if you come across something like this and you're just not sure, do we have a breach or do we not? And then we can skip to 16. More talk about breach. So an important point we wanted to convey to you about the security rule. We talk about encryption. We encrypt our laptops. We encrypt our email. And we caution you because encryption is not strictly required on your laptop or your email. But boy, if you have a disclosure, if you have unauthorized access, if you lose a laptop, if you send an email that's intercepted and it's not encrypted, HHS is not going to look well on that. And you will need to be explaining why you didn't encrypt. And particularly at this stage on the technology spectrum, we really should all be encrypting. So we strongly recommend that you do that. A lost laptop, absolutely, is a breach if the laptop is not encrypted. And the theft of unsecured PHI. So if someone walks out with a thumb drive, or someone walks out with a paper folder that wasn't properly secured, that is a breach. And then we have breach notification requirements under both federal and state law. So one thing here to remember, if something is lost or stolen, but it is encrypted, it is not viewed by the government as a breach. So that's kind of an easy way to protect yourselves. But if there is a breach, then there are these breach notification requirements. I'm going to just flip to the next slide on 17. Just some examples of what a breach involves. Hacking, obviously, that is a risk everywhere. Our networks and our computers are constantly under siege by hackers. So if there is a successful hacking and the information was actually viewed, that is a breach. Improper disposal. I had a case, again, a few years back involving a hospital where someone in the billing department dropped PHI into a cardboard box under her desk with the intention of taking it to the secure destruct bin at the end of the day, and then forgot to put it in the bin, and then it was removed from the billing office by the janitor, and it was taken to the dump. And I had to do a whole investigation there around whether or not that resulted in improper access. And that's not an investigation you want to have to be involved in, because there's no clear answer at the end, and you have to make a risk decision about that. And then loss, right? Loss of a computer or a laptop, unauthorized access to your network server. Thumb drives are a huge risk, right? something, a portable device, a thumb drive is dropped somewhere and you don't know what happened to it, it's not encrypted, you know, that becomes a breach issue, and that becomes reportable, and you have to try to figure out what was on and who was affected, you know, which patients were affected when something like that is lost. So breach areas just to keep in mind. And then, you know, there are some, moving to the next slide, there are some defenses that covered entities can try to raise with the secretary. And those have to do with both knowledge, you know, it's that first tier we talked about a few slides back, knowledge around whether or not you did or could possibly have had knowledge of a particular breach or a circumstance that led to a breach. That's something that requires us material level of proof, you know, back to the Secretary of HHS. And then, you know, if there's a reasonable cause, your staff, you were acting reasonably, you weren't willfully neglecting your obligations under HIPAA, you fixed a problem within a fairly quick period of time. Those are the types of defenses. HHS will hear you out on that. But again, you don't want to put yourself in a position where you have to be defending. And then just a reminder, that there are criminal penalties under HIPAA as well, and they range from 1 year in prison to 10 years in prison. You know, that lower end of the scale if there's, you know, less culpability, and then the higher end of the scale, you know, for folks who are actively stealing protected health information for financial gain. So it's something to keep in mind as well there. And then we can go to the next slide. The breach notification rules, hopefully we're familiar with these. We kind of have them, you know, we have them on our radar in case we have an incident, but we do have to notify impacted individuals. They say promptly, but no later than 60 days from the date you discover the breach. And then when you do that, you typically, you know, depending on how many folks are involved, the notification has to involve some description of what happened. Our server was hacked, you know, the computer was lost or misplaced, whatever it is, some brief description of what happened, when did it happen, what was lost, you know, just your name and your email address were lost or were disclosed, or was it something more significant? Was it their credit card information as well? Was it their medical records that were actually accessed? And then there's some, you know, there's some pretty standard language about steps that patients can take to protect themselves. And then you want to also let them know both the state and federal authorities who to contact. You do want to give them additional options if they want to contact in New York or Maryland, both. You have to contact the Attorney General. You have to give them the contact information for the Attorney General in those states. You want to give them a link to the website for HHS as well. You also want to give them some assurance of what you're doing to investigate and mitigate and make sure this doesn't happen again in the future. You should have really in your pocket, you should have saved on your drive somewhere, a sample letter in case, you know, in the event that you do have to notify folks of a breach. And then just moving to the next slide. You know, this all, of course, depends on the type of notice, depends on the number of people involved. It's just one patient, you have to send them a letter. If it's 10 or more, you can actually post a notice on your website, give a phone number that folks can call. And you can also put notice in the newspaper or other media. If you have more than 500 individuals, you have to both notify the Secretary of Health and Human Services, and you definitely have to notify the media as well. And if you are under 500 individuals, you can just keep a log throughout the year. And I think it's by the end of March, you have to submit your log. There's a way to do that online. You can submit your log and disclose your breach incidents to the secretary on an annual basis. So I do, just skipping through 21, there's some information there that you can read about harm. The bottom line is, yes, patients do have a right now to financial recovery if they're harmed by a breach, but no, there is not yet a clearly defined definition of what harm, what constitutes harm. So we're keeping our eye on that, and perhaps in our next update, we'll have more information for you. And then I did tell you on the next slide, 22, I did tell you about the different levels of criminal violation, and there can be significant fines and also jail time for egregious violations where there's commercial, financial gain involved. That criminal penalty can go up to 10 years. So in terms of next slide. In terms of advice we really urge you to make sure that you have cybersecurity coverage and that your coverage is up to date. And if you don't have it, please talk to your insurance carrier and get sort of up-to-date advice around the advantages of cybersecurity insurance. It's extremely helpful, and honestly, in this day and age, we can't afford to be without it. And then on to the next slide. You want to access your coverage when you have a breach or you think you might have a breach. You call your carrier. Every cyber insurance carrier has experts on their team who can immediately connect with you. I've been through this fire drill many times. They can connect with you. They can give you instruction about exactly what to do about securing the technical asset. They'll engage counsel for you, cyber liability counsel, who put everything under privilege to protect you and make sure that you can complete your investigation out in the open with your lawyers and your cyber advisors, and listen to them. That's your role, is to listen to your cyber expert and to listen to your cyber lawyers, and conduct the investigation, give them the information they need, do the follow-up that they are recommending. And just one last bit of advice on the last page there. What do you do afterward? Well, afterward, you always want to mitigate whatever harm has been caused by a breach, and you want to strengthen your cyber readiness after a fire drill like this for the next time. So figure out what happened, do a root cause analysis, figure out your lessons learned, step up your training. It's always a fantastic and necessary opportunity to do training right after an incident like this. Make sure that you are doing cyber awareness training constantly, training your folks not to open links and training your folks to identify suspicious emails and so on. And then draw closer to your cyber experts. Develop your relationships with your cyber experts, your security audit folks, your own IT teams, etc. And just be the most educated, covered entity that you can be. So that, with 2 minutes to spare, that's our formal presentation. Here's our contact information. If you needed to reach out to us or wanted to reach out to us with further questions, we certainly have enjoyed presenting with you today. And I will just stop there. Michael, do you have a closing word?
Michael Cook had to step out for an emergency dental appointment.
Okay. So on behalf of Michael, then, I thank you for your attention and your time. We really enjoy the opportunity to speak with you. And as I said, if you have any questions, if you have a question you want to send over or you want to email or call us at another time, we're happy to hear from you.
Regina, we do have one question that popped up. It says, what if no medical files are on the laptop, if it's only a portable to an internet site?
Okay, so if you lose a laptop or it's stolen and you're sure that there's no protected health information on that laptop, then in my view, then you do not have a breach. You do not have a HIPAA breach.
Okay. That's the only question that we got. So that concludes today's webinar. Thank you for joining us, and thank you to our speaker, Michael Cook and Regina Morano. Everyone from today's webinar will receive copies of the presentation slides via email tomorrow. If you have any further questions about today's discussions or another healthcare law issue, please feel free to reach out to Lyles Parker or to the emails that you see above. Have a good Wednesday and take care. Thank you, Regina.
Thank you.